Hi, welcome to my channel. My name is Mina Crichton. I hope you've been finding a lot of good tips in my channel. Most of my posts on Facebook are my interpretation of some of the things that I have gone through in my own personal journey as far as being micromanaged and subject to cyberbullying and basically coerced set of circumstance and human trafficking. I can confirm it is my testimony is a personal testimony of an actual individual, meaning me, going through being human trafficked. It's not until you actually experience what is human trafficking you can actually put the content that I have on my Facebook page. They basically, I've sort of used graphic design pictures just to explain and to just get you a bit of an understanding where I'm coming from as far as coming into my world of my footsteps of my journey. Now, no two cases are the same, no two person are the same. You would be completely different individual to myself, so just keep in mind, just a disclaimer, that my personal journey only relates to me. This next episode is about the memos, so I'll be talking about the memos, and this one's really good because I'm going to be mainly focused on the Bill of Rights, and also you will hear how like you'll just get tips on how to exercise the Bill of Rights for yourself as an individual. So basically this next episode we're focusing on the memos and the Bill of Rights. There was several issues during the court case that I had to actually prove, and that was the laws that supports me as the applicant to represent myself. Now, keeping in mind some of these legislations or these laws, they've been deleted or are now repealed. In the order notice of objection for order to strike dated 9th of February 2017, where I made an interlocutory application to enter summary judgment. I had referred the judge to the memorandums in response to notice of appearance under protest of before the fourth named defendant, Steve Colpin, City Med, dated 21st of August 2016. That was the date of the memo. I had put in the memo, and I've actually highlighted it here, and I've put it in the interlocutory application, and this is what it actually states on the memo, just to clarify and confirm that councils were aware, and I've given councils this because that was one of the issues that they were trying to get me to get a lawyer, but I knew I didn't need a lawyer. I knew that I was allowed to represent myself and I was entitled to, and that's what I chose at the time. So this is the rule here. I'll read it out. It says the plaintiff would like to object to rule 1.3. The plaintiff, Mina Crichton, is self-representative and as a New Zealand citizen has the right to have her case be heard in the district courts, civil jurisdiction for intervention. District Court Rule Act 1947 and Rule 57. Here it states, a party to any proceedings may appear or act personally or by a barrister or solicitor of the High Court and not otherwise. And District Court Act 1947 Rule 56A, On the application in accordance with the rules of a person, the court shall, in such circumstances as may be prescribed, to have power to order any person who appears to be likely to have or to have had that person's possession, custody or power, any document or class of documents which are relevant to an issue arising or likely to arise out of that claim. It's going back to the beginning. A party of any proceeding may appear or act personally. So I'm the party in this proceeding and I'm the plaintiff. So this clause here confirms that I was entitled to personally represent myself. So I can confirm that this memo was in the notice of proceeding. So I can confirm that this memo was in the notice of objection for order to strike for the next hearing, which was the 27th of February 2017. So I can confirm and verify that this memo was also had eventually became an exhibit, and that should have been in the court file for the judges to cite. I've also referred in my legal documentations the Bill of Rights that fully supports my case, and that's the New Zealand Bill of Rights Act 1990, Public Act 1990, and 1(2) Rule 8. Right not to be deprived of life. Rule 9, right not to be subjected to torture or cruel treatment. Rule 10, right not to be subjected to medical or scientific experimentation. Rule 11, right to refuse to undergo medical treatment. I'll pause there. Now, the Bill of Rights I've just noted is when somebody says no to a doctor, you have that right to exercise the Bill of Rights. They have no right to put any pressure on you as a patient. No means no. It doesn't matter if they think it's life and death or whatever. If the patient says no, it means no. So I was exercising my Bill of Rights with my employer and with the doctors. And so that's why I've used these Bill of Rights Act. I'm basically enforcing them to protect me as not only the patient, the plaintiff, and the applicant, and also the victim in this matter. I was just exercising my power of right as an individual. Rule 19, freedom from discrimination. Discrimination is actually a very serious criminal crime, like it is an offence. Discrimination is definitely a criminal offence. Any form of discrimination, that is what I was going through at the time. And then I got, everyone has a right to freedom from discrimination on the grounds of discrimination in the human rights law. in the Human Rights Act 1993. So I've enforced the Human Rights Act 1993 and Rule 22, the liberty of a person, because that's what happened. Well, basically, when I look back at my whole case, historically, periodically, all those incidents that I went through, I felt my liberty as a human being was taken away from me, and that is what human trafficking by force does, where the person's liberty is actually taken away and their dignity. It's all consistent with the ongoing psychological and mental abuse within the environment or within the moment that the actual individual is going through, or the path or the journey they're going through. So I've used Rule 22, the liberty of the person. Everyone has a right not to be arbitrarily arrested or detained. So when they actually use the Mental Health Act on somebody, liberties is completely taken away. They have no rights whatsoever. And that's when the authorities have that, power to take over your circumstance, and you don't have a say as an individual while under that Mental Health Act when it's been enforced, and nobody in your family can intervene or have anything or any say, because that's what the Act is for. It gives the authorities the authority to have that power, it's like a power of attorney where they take over everything. And also, I've just read about how everyone has the right not to be arbitrarily arrested or detained, because I said no, but they arrested me because they were using the Act. But I said no, and I actually refused to go. I didn't want to go, and I actually reacted at this time where I tried to ring my son when I was arrested, but he was confused about the whole situation. My family was confused that were there at the time because no one could do anything. They had been convinced that I needed to be locked away. But I was really upset that evening. I was very distressed. In fact, it was that bad I didn't want to go when the police officer came into my room to arrest me, because they came during the night. I think it was about after 11 p.m. at night. 2 police officers came. One guy's name was Alan. I heard them coming. I was in bed. I didn't even have a bra on, and he came in and they said I had to go. I kind of got distressed and panicked and rang my son to help me, but like I said, he didn't know what to do. I was really distressed, and I was absolutely upset, and I was angry and I was scared at the same time, and he wouldn't even let me put my bra on because I was still in bed, and I was absolutely upset how they, just being powerless. And I knew what was going to happen. I knew where I was going, and I knew I didn't belong in there. I was very traumatized through the whole incident. But I had no choice, and I had to go. So they did arrest me. They took me and they locked me up. Rule 23, rights of a person's arrested or detained, and Rule 27, right to justice. Now, as I've already mentioned, when it comes to the Mental Health Act, when that has been enforced by a psychiatrist, we don't have the power. We can't do anything. You have to go along with it. But that can be challenged in the court. So I had to actually wait for the next court hearing for me to actually dispute my case in regards to the Mental Health Act. Now, it doesn't matter what laws and once it's enforced, but according to the laws, as the individual themselves, they still have rights, which means the court don't have that power. They have to be absolutely 100% to actually keep that enforcement power of the Mental Health Act on an individual, so they can keep using it. But that was the other frustration I had, was because I knew I was set up. I knew that they had no medical evidence. I knew I was subject to historical cyberbullying. I knew that something like this was going to happen to me, and it did happen. However, I did go through the court process, a proper court process, and that was dated on the 9th of February 2016, and all my family members were there, and a family member friend, and my lawyer was there. She was a mental health specialist lawyer. She was there. And then there was that other nurse, the one that I have talked about, whom I've never met in my life, and convinced my family to make me stay in there for another 2 weeks. She actually tried to convince the judge too. She was in that court hearing. There was a registrar in the court hearing. There was a judge in the court hearing. And there was a security guard in the court hearing, whom I knew because I worked with him at work, so he knew who I was. Everything was out of my hands, and I was at the mercy of the judge to not let me stay in there, as it turned out. Now, if that recording was used for evidence, by law I have that right to obtain that recording, what actually happened in the court hearing. I did exactly the same thing that I went through with Dr. John Joseph with the CD. I know I put that CD on Facebook. I reacted out of desperation because nobody was listening to me, and I was basically acted out in desperation, and I went on Facebook because I needed help, because that's the predicament I was in. I was in such a very serious, dangerous environment for me mentally, for my health and safety issue, and all the rest of it, because it was an alliance. So that what happened in the court case, I basically was trying to convince the judge that I shouldn't be there, and because I told him that I was subject to cyberbullying, and then I did exactly what I did with the psychiatrist, Dr. John Joseph. So all I did was walk him through as fast as I could. I was talking really fast, and I told him that I was a registrar. But in my voice, I was kind of like, I was begging, but I was like kind of pleading with the court. I was begging the judge not to let me stay in there, because I didn't want to stay in there, and I ended up winning that part, and he. So I did. He actually said she has rights. She doesn't have. She doesn't have to. If she doesn't want to stay here. The thing is, the doctors had nothing strong to prove to the court that I was. The doctors had no proof to prove that I was a high risk patient. Even though I ended up getting what I wanted and I was released, I was still shocked at the fact that I was there, and I still couldn't understand how they got it wrong. Like I said, there was no medical evidence, so I just couldn't understand how the judge could have even got that wrong, because you need medical evidence for them to obtain somebody. All I can think of is that they may have switched the medical records, which there's a very big percentage of that being likely to happen. Historically, that's what's happened to me, been cloned and then switched, and then evidence have been deleted. In theory, a conclusion, that's all I could think of what actually happened is, because when I was in there, a nurse even said to me, "You don't belong here." And I says, "Yeah, I know I don't belong here." Did my best to hang in there until I went out, stayed calm. And I had a friend who visited me. I already mentioned he came to see me, and me and him had a meeting with one of the nurses, and he tried to convince the nurses and that they got it wrong, and that I was subject to workplace bullying, and that our employer was going through some kind of culture thing where they were getting rid of people because it happened to him. If I can remember rightly, the person's name was Kim, the nurse. I think her name was Kim. Yeah, I actually had her details in one of my documentations. The public scrutiny has been seriously dangerous, where they're into everything. People are taking the law into their own hands because they think that they have that right and that power too. You talk to them and they don't tell you the truth. So that's a predicament in the environment that everybody is in if, you know, they're subject to something like I have. So it's a very life and death set of circumstance for myself. And anything that they have accused me of, the public hasn't heard my side of the story. Everybody's got different culture and beliefs, but I feel like that's what's happened to me. Other people have forced their culture, their belief on me, or have tried to change me to be like them. Whereas I'm still me, and I'm a direct person, I'm a very forward person, and there's nothing that I'd say secretly that I wouldn't say to that person if given the opportunity to. I'm a very forward person, and so it's quite obvious that what's happening with this sort of system where, you know, individuals are being micromanaged by the opposition, I feel like they're targeting certain people for certain reasons and then doing what they're doing, whether it's a way, obviously it's a way to take over their personal territory, which is invasion of privacy. But, you know, it seems like they're targeting people or people who have got a lot of experience, and they're grooming people.